I apologize, everybody, for the technical difficulty. This is Rob Scott, and I want to thank everybody for joining. This is a presentation on cloud computing, and we have a wide variety of guests in the audience today. In fact, my team reported that this is the largest turnout for any webinar that we've had of this type. So thank everybody for joining. We have representatives from both sides of the aisle, so to speak, many sourcing professionals, as well as representatives from service providers. We have a large contingent from the legal industry, both in-house and outside counsel. So I want to thank everybody for joining today and look forward to a good presentation. A few years ago, my partner Julie told me that the trends toward cloud computing were merely nothing but a buzzword that would come and go quickly. Today, the trend toward cloud computing is irrefutable, and the growth in cloud and service models, as well as software as a service, have really taken over the industry in a very short period of time, leaving many to deal with some of the questions from both a legal and regulatory and risk perspective, while business units are clamoring for the benefits of cloud services in terms of its flexibility and in terms of its easiness to deploy, the fact that you can account for these services on an operating expense basis as opposed to a capital expense basis, are all major trends toward and shifts away from the on-premises perpetual license model that existed for many years, now toward a complicated hybrid of infrastructure, services, and software being delivered through a variety of mechanisms, all generally being referred to as cloud. So today I want to talk about, the kinds of issues that we see when a client comes to us and says, hey, I've got this cloud contract and I want you to talk to me about what you see in it, and we want to get your advice. These are the issues that I'm generally focusing my attention on. In the on-premises world, intellectual property ownership was not that big of a deal. The vendor, the publisher, owned the code and the documentation, and the customer owned everything else. The customer was prohibited frequently from building reverse engineering or disclosing the confidential information of the publisher, and those terms became so ubiquitous in software contracts that as lawyers we considered them to be the basic boilerplate that was infrequently negotiated. However, with cloud models where there's a closer collaboration and a less clear line between who owns what in the system, where the publisher is delivering code and the customer is delivering content, and the customer and the publisher are collaborating on enhancements and customizations and configurations, the question arises, who owns the IP? And what I like to talk about in this context is each party owns what they brought to the relationship at the beginning, and the customer owns everything that they pay the publisher to develop on their behalf. If you follow those rules, I think you'll be guided very well when you're dealing with intellectual property ownership. The biggest change from on-premises software licensing transactions to cloud transactions is around risk. And therefore, almost all the time, in every case that I'm negotiating, we're getting into provisions that deal with risk balancing, including insurance, indemnity, limitations of liability. In the historical on-prem licensing world, the concern was a patent troll would come along and sue an end-user customer alleging that the software violated the patent troll's patent, and now for some reason they have to uninstall it, or there's a disruption in their ability to use it, and they wanted the vendor to indemnify and hold them harmless for third-party IP infringement claims. And beyond that, indemnity in the traditional software licensing world was very rare. Even today, there are major publishers who do not offer indemnity to their customers. And a lot of that comes from the fact that historically indemnity in software licensing was very limited. In fact, limited only to third-party IP infringement claims. But today, in the cloud world, where data is residing in systems, where there's a potential that customer information could go missing, where there's a potential that regulated data, healthcare information, financial information could go missing, now with the cloud, we've got a whole new set of issues that didn't really exist in the same way in the traditional on-premises perpetual licensing models. The other thing that we see a lot is the fact that not every solution is being delivered by the seller. Many people are bundling and partnering with other IT providers to deliver a bundled solution under a single contract. And so it's often interesting to see, as you dig down into who's delivering the services, some of the legal limitations and liability implications and regulatory implications of involving third parties to a contract. The other thing that we see in the cloud context that we didn't see as much in the on-premises model, but we saw a lot in software as a service contracts, is how do we get divorced? What happens at the end of the term? What happens if I need to cancel? How do I get my data? I've put my data into your structured database tables. How will I get it back? Am I limited to the reports that I can run out of the system? Is there some obligation on the part of the vendor to assist with a seamless transition or to provide some support in connection with a potential migration either to another provider or back to an on-prem or proprietary solution? The other thing that we see as a holdover from the services side of the business of cloud is a lot of service level type provisions, service level agreements, things that would be holdovers from the old telecom days that creep their way into being important in managed services. Now we're starting to see the service aspect, availability, response times, now creeping into cloud contracting. So if you think about this risk profile of cloud and how it relates to on-premises perpetual licensing models, you can really break them up into these categories of risk. And the business continuity risk is one where what happens if the system is down? You know, take for example a cloud service that's designed to process payments for a multifamily apartment management company. You know, if the system is down, rents are not being collected. That is a significant business interruption. You know, if your cash registers are off, that is bad for business. So there are business continuity risks when you start putting your primary applications in the hands of a third party. There is always a business continuity risk that something happens to that third party or that software or that connectivity or the various failure points in any IT infrastructure that could leave you down, could leave you in trouble from a business perspective. And yet when you look at the typical cloud contract, almost universally they have a limitation of liability that excludes these types of injuries. The very types of injuries that would occur from a business continuity perspective, lost profits, lost income, loss of customers, almost universally disclaimed in cloud contracts today. So you need to think about the business continuity risks. The regulatory compliance risks are where I spend most of my time. 5 years ago, if you told me what will become of the cloud, I would tell you that the cloud will be the predominant service model for B2C and for SMB market, small business market. But when you get into large enterprise, when you get into regulated entities like healthcare and financial services, cloud-based solutions really don't fit. Yet in the last year, I've spent a large percentage of my time helping some of the world's largest banks and some of the country's largest and most prestigious healthcare institutions to get into cloud contracts in a way that is compliant with their regulatory requirements and makes good business sense for their companies. The intellectual property risks we talked about a little bit, but use and disclosure of information is one of the biggest. You know, if you've got an on-premise system and you're putting your data into that system, you have certain control over trade secrets and other confidential information, non-customer information, but things that would be important to your business. I use the example of the recipe for Coca-Cola being the most famous trade secret. But all businesses have trade secrets, things that if they got into the hands of their competitors would become unfavorable for the company. And when you start putting that type of information in a cloud-based system, you have to make sure that you have the appropriate provisions in the contract. Lastly, risk balancing. As I said before, we spend most of our time in this area. Most cloud contract negotiations ultimately boil down to the limitation of liability, the indemnity, and the insurance and the ability to access professional liability insurance. So how can you deal with business continuity risks? Well, one of the things that I like to do is really get clear on what is the service. What is it that we're expecting, defining the service level, the metrics, and remedies in the event for service failures is a key piece of the puzzle when you're dealing with a business continuity risk. Why? Because if you've done your contracting correctly, if you have a problem with a vendor, then you need to be in a position to objectively cite to the contract to establish a breach of the contract. And if you can do that, it puts you in a stronger position. The other thing to think about with business continuity risks is you need to have your own data and your own BDR solutions in place as a backup to the backup. Do not think that it's appropriate to put your data into somebody else's cloud and rely on them to be 100% responsible for the backups. Because if you look at what you're doing operationally, with many clients relying on the vendor 100% for data backup and data recovery, if you look at what type of legal responsibility that vendor is taking, it doesn't align with the operational commitment that has been made. And so it would be foolish under the circumstances, in my view, to put key data into a cloud-based system without having your own independent way to back up the data and at least to test and to restore the data in the event of an issue. And we've developed some pretty sophisticated strategies. We as an industry have developed some pretty sophisticated strategies to deal with business continuity risks in the cloud, including very innovative escrow arrangements whereby a third party is charged with maintaining a separate live production version of the site with your data in it, and so that if the escrow is triggered or there's a problem, you've got a combined third-party independent disaster recovery solution and a traditional escrow arrangement. So there's something that there are steps that can be taken, but I feel like in today's world we've got a rush toward the cloud, with the cloud industry taking very little legal responsibility for the outcomes in terms of data loss and business continuity. When we deal with IP issues in cloud contracts, a lot of it is around who owns the data, how do we define customer information, and then when it comes to customizations and enhancements, who's going to own the customizations and enhancements? Typically, the vendor is going to say, everything is a derivative work. Even if you pay us to do it specifically for you, we still own it. And frequently, the end user customer is going to say, no, we're going to treat anything that we have you develop as a work made for hire, such that you develop it for us, we own it. And so those can be some pretty contentious discussions, particularly because intellectual property issues around software are pretty sensitive issues, and for good reason. On the regulatory compliance front, I would say that if you're a bank or a healthcare company, your biggest hurdle to the cloud adoption, particularly involving customer information or healthcare information or financial information, is going to be regulatory compliance. And this is what led me years ago to say that the regulatory framework is such that banks and healthcare organizations really are not a good fit for cloud. Over the years, however, rules have been identified. There's been additional guidance from the government and the regulators around how you can adopt cloud solutions. And I think the key issue is around diligence. You must perform due diligence. And I find that in the rush to move to the cloud, sometimes the due diligence is inadequate. And that due diligence is to deal with making sure that you don't select a vendor that puts your customers or your patients' information at a greater harm of disclosure than an alternative. It doesn't mean that you have to choose no risk solutions, nor is there a bright line rule that says, for example, multi-tenanted environments violate any particular regulations, or that if you go dedicated in a particular hosted or cloud-based environment, that's the bright line. In fact, the tests are very amorphous, and they have to, in most cases, your diligence obligations will run with what is reasonable for the nature of your business. A large bank is going to have a different set of reasonableness standards applied to it than a local credit union. A small healthcare clinic is going to have a different set of reasonableness standards applied to it than a large chain of hospitals. And so this is what makes it a challenge to make sure that you're discharging your responsibilities. And what we find is that in every industry, whether it's healthcare, financial services, the contracts that we get from the vendors initially do not comply with the customer's regulatory obligations. In fact, when we represent banks, there's a very bright line rule about in GLBA that deals with selecting vendors, the types of specific type of language that must be included in the contracts. Similarly with HIPAA and the business associate agreement, and yet in many instances, clients will bring to us document packages for our review that have none of the required elements. And the regulators are looking at this stuff. They're coming through and saying, show me your contracts with these vendors. Where's the required language? So it is a big impediment. You have to have a good, if you're interested in cloud adoption, you must include regulatory experts as part of your team, particularly if you're in a regulated industry, because you're going to have a lot of hurdles around compliance in order to do this correctly. The other thing that arises pretty frequently in the context of cloud contracts is who is going to be responsible if the data goes missing or there's a compromise in the system and we have to give notice under state data privacy rules. As many of you are aware, many of the states, and including the federal government for certain industries, have data breach notification rules and laws, and they're very expensive to comply with, and frequently a notice is required even where there's no harm or even threat of identity theft. And so managing in a cloud contract who is going to, making sure that those notices are going to be provided, and who's going to pay for that, more importantly, are important provisions to include in a cloud contract. So indemnity. Indemnity is one of these words that I think people see in legal contracts, and even I think some lawyers don't fully comprehend the significance of indemnity provisions in cloud contracts. Indemnity is a provision that says, in the event of a claim by a third party, one of the parties to this contract will defend and hold harmless, pay for damages as a result of such a claim. So, for example, it's common to say that one party will indemnify the other party for that party's gross negligence, any claims that arise from that party's gross negligence, or willful misconduct, or arising from the service. But yet when you see a draft contract for a cloud service, even among the largest vendors, ask yourself, what is the indemnity that the vendor is offering? In some instances, you'll see the old throwback to the note, I'll indemnify you from third-party IP claims, but rarely will you see an indemnity that says, I'll indemnify you for any claims arising out of our services. And frequently what you'll find is a customer contract that says, we have insurance, that the vendor has professional liability insurance, but the indemnity obligation that it is not as broad as the insurance grant, basically are in conflict in many cloud contracts. In fact, we have helped some of our clients when trying to adopt cloud solutions revisit their own insurance, first-party cyber liability insurance, to cover risks that would normally be addressed in an indemnification provision. What if you're in a deal where you really want to do the deal, and the sticking point is risk balancing? The vendor says, I self-insure and I don't offer indemnity, and I'm going to limit your liability to 12 months of what you pay me under the contract. The lawyers then say, that's ridiculous. We can't take that kind of risk. And so the risk management people come to the table and say, hey, wait, what if we get our own insurance? It'll cost this much for the premium. And if there's anything that happens from a cyber liability perspective that would normally be covered by the vendor, now we have our own first-party coverage. So that can be a solution to risk balancing, just having the customer add first-party coverage to fill in the gaps that are left by the contract. I would say if there was one provision that we spent most of the time on that was the kind of most typical final deal point, it would be limitation of liability and liability risk. And I think that the reason is that the vendor is saying, I've got this deal. It's a multi-tenant deal. I'm offering it to everybody. I've got a certain price point that I need to deliver it at, and I just don't have this much risk built into my pricing. I'm not an insurance company. And then the customer is saying, look, I can't in good conscience entrust my customer information to you, which if it goes missing could cost me millions of dollars, and I've got a limitation of liability that's tied to what I've paid you for the past 12 months. What if I have a breach, and what if there's a breach of your system after 2 months, and I've got to notify 1 million customers? Who's going to pay for that? And so the discussions go on and on. And what I'd like to do, particularly in the mid-market and the small enterprise, is use professional liability insurance as a tool for risk balancing, where the vendor goes out and obtains professional liability insurance that is appropriate in terms of the coverages. What I mean by that, it includes cyber liability, breach incident response, regulatory response, all of the key coverage types that would be relevant to a data privacy incident. And the vendor goes out and buys that one time for all of their customers, and then each of the customers is covered to the extent of the insurance. That's great, provided that at the same time you don't use the limitation of liability and the indemnity provision to limit the customer's ability to access the insurance. I can't tell you how many times I've negotiated contracts where there's a great insurance provision in it. I mean, detailed. We've got this and that and great aggregate limits and all of the coverage types that a client would want. And then when you go to the indemnity, it says basically we don't indemnify you for anything. And then when it comes to the limitation of liability, it says 12 months of what you paid me. So why are they carrying that insurance? I mean, if the insurance is there to protect the customer, then why limit the insurance, limit the customer's ability to access the insurance by putting these conflicting provisions into the contract? So we deal with this. There's a number of different ways to skin the cat on risk balancing, but the one I like the best is where the customer agrees that it will accept the greater of the insurance or a multiple of what's been paid for certain types of claims. And then there's a carve-out altogether for other types of claims, such as gross negligence or intentional misconduct or a breach of a privacy issue. In some instances, we like to, we're okay to have a broad limitation of liability, and then we carve out covered claims from the limitation of liability, so you don't get into this conflict between available insurance proceeds and a limitation of liability that is very low. So the other thing that I think is important is calculating what it is that your risk profile really is under an agreement. And then looking at how does a common or potential claim scenario compare to what the limitation of liability would yield in a hypothetical situation. Take a data breach, 1 million customers, right? Now we say, okay, we're going to postulate that it's going to cost us $1.44 per customer. We got a $1.44 million issue here, and we're going to go to the draft contract and see how would the risk of this incident be balanced between the vendor and the customer. And what I would say to you is, in most cases, you would find that the customer would be woefully and inadequately protected under the terms of most cloud agreements. And the reason for that is that 1.44 million is likely to be a significant multiple of the subscription fees that have been paid. And most cloud contracts tie recovery to some number of months, some time period, or some multiple of months or time period of revenue. So I would say the most common is our limit. In any event, our liability will be limited to 12 months of the prior services. You know, my clients with great bargaining power can get 5 times, 4 times. Sometimes we see 8 times. But usually the starting out draft template document that you look at will be 6 to 12 months. And then even then, significant carve-outs for the types of things like claims arising from customer data or lost profits or business interruption. All of the types of things that would be common claim scenarios frequently excluded in a limitation of liability. So one of the trends that's emerging now is in the cloud, and we're seeing in the courts, is fighting over applicability of limitations of liability, whether or not a particular limitation of liability is against a public policy in a particular jurisdiction. So choice of law issues become very important when you're negotiating limitations of liability. For example, if I'm negotiating a limitation of liability and the issue is that I want to carve out for gross negligence and intentional misconduct, I don't want that to apply to the limitation. I want that to be uncapped. And the vendor will not agree to that. If I could get that same vendor to agree to a New York choice of law, which frankly is sometimes pretty easy to do, then because New York law expressly prohibits disclaiming of gross negligence and intentional misconduct in their contracts under the general obligations law, then I've accomplished the same thing, even though I didn't change the contract. So on the face of the contract, it contains the limitation of liability, but going into it, we know that there would be no enforceability of such a limitation in a case that arises under New York law. So when you're looking at limitation of liability and you're working on your carve-outs and you're looking at liability risks, take into account, look at, compare the language, and go look at the cases in that jurisdiction where the choice of law is specified. And sometimes you'd be better off choosing a choice of law jurisdiction that has limitations on the extent and nature of limitations of liability. You may be able to accomplish that easier, for example, than coming to terms on the language. So risk mitigation strategies. Require vendors to assume liabilities associated with the service. To me, this is the most basic premise. If I go to a lawyer and the lawyer gives me bad legal advice, it just goes without, and I'm injured as a result, it just goes without saying that that lawyer is going to have either self-insured or professional liability insurance to cover that risk, and that they're taking legal responsibility for that. In many cloud services agreements, the vendor is not taking responsibility for their employees' own negligence. You're entrusting these vendors with very important business information, in many instances regulated data, and the contract itself says they have no legal responsibility not to be negligent. That's a bad model. Bad model. The whole point of this has got to be that the cloud vendor can deliver the services in a manner that is at least as safe for your customers as you could do it yourself or the next person could do it. And if they have no legal obligation to do it, why would they spend the money to screen their employees, to train them, to do all the things that are necessary to keep your data safe? it creates a bad incentive structure to allow cloud contracts to not have the party who's delivering the services take legal responsibility for, at the very least, the negligence of their own employees. Specify insurance coverage and make sure that your coverage requirements are broad. Typical contracts these days will say, well, each party agrees to carry appropriate insurance. Well, what is appropriate? We've got to specify what we want. Breach response, regulatory response, consumer claims, breach notification costs. All of these things need to be clearly specified with the aggregate limits that are appropriate to the nature of the claim scenarios that are potential for a particular client's situation. Use indemnity provisions to protect against liability. If someone sues you and the vendor has agreed to indemnify you and hold you harmless, you give them notice and they take care of the lawsuit. They have an obligation to defend and indemnify and hold you harmless, not you having to deal with a lawsuit because you chose to go with a particular vendor. Focus on limitations of liability. Make sure that the limitations of liability are appropriate and that they will cover you in the event of your common claim scenarios. And if they're not, then you need to think about supplementing that with your own first-party insurance coverage. We have about 15 minutes remaining, and I'd like to open up the floor for questions. We have a couple of questions already that have come in, and I'm going to start going through those now. The first one is about third-party escrow arrangements. First question is, who is providing such services? I would say one of my clients for many years that I think very highly of, who I think is the absolute leader in this field, is Iron Mountain. Iron Mountain's solution for software as a service and cloud when it comes to escrow is phenomenal. The next question is, does the cloud provider ever pay towards such services? The answer is typically not. Typically, escrow services are for the benefit of the customer and frequently paid by the customer. That being said, it could be a negotiation item in any situation, and you could either trade off other things or in some instances, because the vendor is able to leverage it, sometimes there is a shared cost model. I would say even if you have to pay for it yourself, having an appropriate escrow arrangement in place is worth the money. Last question in this category, what obligations are needed from the cloud provider? That would be something you'd need to check with Iron Mountain, but they would need to be party to the escrow agreement, and there would be certain deposit requirements, and that would include giving Iron Mountain access to the software to install in their data center to run their hot backup live solution. So at the very least, it's going to include, signing the agreement and cooperating with Iron Mountain to set it up. Next question is, what are the top 3 risks from the customer's perspective and the top 3 risks from the cloud provider's perspective in relation to cloud contracts? We've talked mostly from the customer's perspective, but as many of you guys may know, we have a significant practice in representing cloud service providers, and probably the most typical engagement that we get as a first engagement from that group is help with their customer contracts. And I would say from the cloud provider's perspective, the biggest risk is getting caught in the middle between a vendor that they're reselling and their customer, where the vendor has a failure that results in an injury to the customer, that now the provider is stuck with liability for something that it didn't do. I would say that's the biggest. Also, provider risk, I'll go with network security and data privacy. If your client's data goes missing, if your client's backups don't perform adequately, if you have hardware failures combined with backup failures and client's data goes missing, these are the fact patterns that lead to court cases. And so the flip side of the risk balancing provisions that we talked about today, the provider needs to be thinking about those risk balancing solutions as well, and they certainly shouldn't be thinking about taking on more risk than what they've transferred. When I represent service providers, I like to put them in what I refer to as the zero risk position, which is basically going out, getting great insurance for their customers, professional liability, and then giving the customer broad indemnity and a limitation of liability that says the customer, for the most part, is going to be looking to the insurance to be covered for any injuries. The next question is, if a cloud provider insists on capping indemnity obligations, for example, for data breach, have you been successful in referencing the cloud provider's insurance for a cap amount? I think the answer to this question is yes. I'm not sure, what successful means, and I'm not exactly sure about what referencing the provider's insurance for a cap is about. But I will tell you this: it is frequent that we do super caps for data privacy issues. So it's not uncommon that we'll have a separate provision that deals with the indemnity and the limitations of liability for loss of customer data or breach. And so in that instance, if there's a cap, you would definitely want any cap to be tied to your common claim scenarios. If your claim scenarios exceed the cap, whether that cap is expressed as a multiple of revenue or as an aggregate limit of insurance, then you have a problem. Next question. Regarding insurance and liability cap, would you provide a caveat that the claim must also be covered by insurance in case carrier denies the claims? Typically, what we have is a scenario where you've got the insurance, and if you're from the customer's perspective, you want the greater of the insurance or whatever negotiated financial cap you can negotiate. In some instances, from the provider's perspective, if they're trying to limit it to insurance, then the provider will want to say, in the event of a coverage dispute, then the provider is not required to file a declaratory judgment action, because you could have a coverage dispute. And if from the customer's perspective, if you're in a deal that's limited to the proceeds of insurance, and you have a coverage dispute, and all liability is otherwise disclaimed, then you have nothing. So that's a concern. So that's why, from a customer's perspective, I like to have a uncapped for certain types of claims, higher caps for the more common claim scenarios, and no limitation on insurance to cover, for example, claims that would not be covered by insurance, such as intentional acts, criminal acts of third parties, etc., not likely to be covered. And so in those instances, I like to have, when I'm representing the customer, is a variety of pots to go after, including maybe a revenue-based pot and a proceeds of insurance pot, and get the greater of either pot is how I typically negotiate those. I think we do have a couple of more questions coming in here, and we still have about 10 minutes for questions. The next question is, what about the applicable law and jurisdiction? If the customer is a company not located in the U.S. that has to respect specific local data privacy laws, what can be done? In any case, which law and jurisdiction within the U.S. do you believe is the best option for a company located abroad? That's an excellent question. I would say that as a general proposition, the most common jurisdiction that we see in software licenses, it would be what I would consider a neutral jurisdiction for most cases, is going to be New York. Another one that we see a lot of is Delaware law. But if I'm an out of country customer, and I'm doing business in the U.S. and I want to pick a jurisdiction for the U.S. to be my sort of standard jurisdiction to go to, I would recommend New York law. Next question. Is it fair to ask a cloud provider to assume unlimited liability for third-party IP infringement claims? Can this be regarded as an industry standard? I would say yes. I would say it is fair to ask a provider to take 100% responsibility for IP infringement claims related to their IP, and that it is fairly standard for providers to make such an agreement. Next question. Most cloud provider agreements have the right to terminate for convenience upon 30-day notice. Do you find that they are willing to negotiate this, as this is as great a risk as an interruption of service? I would say yes, 30 days for convenience is outrageous, particularly if there's a significant amount of data or a large organization involved. And yes, we have negotiated for term and termination provisions, and I definitely don't think that it's appropriate for a vendor to be able to exert that kind of pressure on a customer to say, basically, if you don't buy this or do that or do what we're asking you to do, that we're just going to terminate you in 30 days, knowing that you've got a significant switching cost and an investment in business operations. Such a provision would be unreasonable, in my opinion. Next question. For dispute resolution, do you feel arbitration is an appropriate venue for resolving disputes in the cloud computing space? I would say yes. I think arbitration is particularly well suited to cloud disputes. I have cases right now that are both in arbitration and in the state courts, and I find that the arbitration forum is better in as much as you have the ability to select an arbitrator with some amount of technical background. What you don't want, either as a cloud customer or as a cloud vendor, is to be in a court case where you've got a judge whose background is in real estate law, and their idea of technology is they've got a dictaphone in their office. So I would say that with arbitration, you're able to select a judge that has the subject matter expertise in technology, and I think that can be important to both sides. Next question. Some cloud vendors have breach notification of up to 30 days. This seems unacceptable for data that is PHI, MPPI, or FTI agreed. 30 days in most instances would put you in direct violation of many of the laws that are designed to protect and safeguard and require notice. I mean, most of these statutes talk about immediately or as soon as is practicable, and under no circumstances would 30 days be an appropriate time frame to give notice. Okay, well, thank you guys very much. If there are any other questions, feel free to submit them, and we'll take them offline to the extent that we can. I want to thank everybody for attending today. We have a few short administrative announcements, including the CLE numbers. Thank you, guys.